President Trump submitted his 21st emergency order to the Supreme Court, which is more than President Biden submitted during his entire 4-year term. And President Trump has been on a huge winning streak, given him the green light to move forward with his sweeping agenda and major policy changes. That doesn't mean the issues are decided, but they've allowed him to move forward while the issues are litigated in the lower courts. Some people say this is a staggering abuse of the Supreme Court's emergency docket. The Trump administration says that activist federal judges are the reason why they have to use this particular strategy. And other legal experts blame Congress for being missing in action. Emergency orders, also called the shadow docket, don't actually decide questions of legality. But where the Trump administration has been very successful is getting the conservative majority Supreme Court to side with him, saying that lower courts cannot block his orders while they make their way through litigation. He's been able to carry out a big part of his agenda, even though the legal issue hasn't been decided. For example, the Supreme Court lifted a lower court order blocking the Trump administration from swiftly deporting people who were here with temporary legal status. That cleared the way for the Trump administration to deport those people, even though the legality of his action hasn't been decided yet. The Supreme Court also allowed the administration to freeze $65 million in teacher grants. They allowed DOJ, the Department of Government Security, to have access to sensitive Social Security data, mass firing of probationary employees, and they allowed the dismantling of the Education Department. Now, none of those cases is actually resolved. It's just that the block that the lower courts had put on the administration being able to move forward with their policy while it was litigated has been lifted. These decisions on emergency orders are not supposed to set precedent, but interestingly, the Supreme Court sometimes rebukes lower courts for not acting in accordance with their previous rulings, which has led many legal scholars to believe that the court is about to overturn a 90-year precedent which blocks the federal government from dismissing independent agency leaders without cause. Two particularly troubling outcomes of this emerging trend are, one, the potential for different policies in different states, as we saw with birthright citizenship. The birthright citizenship order has been blocked again, but the potential was there for different states to grant citizenship based on different criteria, which makes no sense at all. The other concern is what harm it may be causing to the defendants. For example, the Supreme Court overruling a lower court's order which prevented deportation of migrants from the United States to a third country, not their country of origin, undoubtedly could cause harm. A Venezuelan migrant who finds himself deported to South Sudan certainly will have been harmed if that order is eventually deemed illegal.